Good evening. Well, Brad, I tell you, it's amazing what you've done in just a few years. And I think at a time when there's such incivility in so many quarters, what a wonderful organization for us to come together and to talk about the great issues of the day. So let's give Brad and his team a round of applause. I guess my one regret when I think about my 20 years, 3 months, and 2 days on the Supreme Court of North Carolina, not that I was counting, is I didn't get to serve with the great Justice Tamara Barrender. Let's give her a round of applause. One of the blessings of my life is knowing Justice Barrender and her husband for at least 30 years, maybe beyond that. And of course, we were all 12 at the time, 30 years ago, and that's our story, we're sticking to it. So anyway, we're just gonna have a good time tonight. Now, I was in public service about 30 years, and there was something I would always forget to do. And that was to introduce my wife of 30 years, Kim Martin. She really gets all the credit for successful statewide campaigns. I still can't believe that the last time we had 72% of the statewide vote, but then I consider who my opponent was and it all made sense. But, I'll leave it there, not to say anything negative about anybody. So Wes Jones is administrative counsel at the law school, and Wes, thanks for helping me out tonight with the presentation. Wes was a law clerk at the Court of Appeals, then went into private practice of law. And then I took him on a golf cart ride at the university, and we were working together a few months later. So High Point University, if you haven't been there, is just an amazingly beautiful place. Looks a little bit like Disney World. So if you get a chance, when you're going down I-40 or I-85, I'm just about 15 minutes off the interstate, so come by and see me. I'll promise you barbecue or a glass of wine or whatever you want to have. You'll have a good time checking out the university. So for those who don't know me, most of my professional career was in public service. As a young man, I clerked for a federal judge, and then I went to a very large law firm and primarily represented banks, did appellate work, federal litigation. And then I became legal counsel to the governor, a guy who really didn't have much of a political background. And that governor then appointed me to the bench. His name was Jim Martin, and he was no relation, but he was only the second registered Republican to serve as governor since Reconstruction in the state, which goes back a while. And so I really was amazed with the competence and the integrity of this gentleman. He has his doctorate in chemistry, not your typical politician, very well educated. And he ran for governor because he wanted good government. And that's what he sought the 8 years he was in office. So I became a judge at that point. Went on the Superior Court at the ripe old age of 29, and then I went on the Court of Appeals at the ripe old age of 31, and then I went on the Supreme Court at the ripe old age of 35. So I've had just a wonderful life, and if I had to go to heaven tonight, I'd be one of those guys that said, this has been a lot of fun. And the greatest part about it are the people that I was able to work with. And you here tonight, we have great momentous issues for decision in this great state, in our nation, and around the world. And it only works out right if we care enough to show up and to get engaged. So I'm proud of each and every one of you here tonight. So with that said, let's hop right in. Now, just so you know, this title was not original with me. And so I think everybody knew that. So, we have a joke first. Now, I'm going to try to change this. First day of law school. See this incredible young man here? Last day of law school? We don't want legal education to do this. And over here, first year of law school, great ethics and morals. Last day, final year of law school. Regrettably, right, Brad,
Yeah.
we've seen a lot of this. And so at High Point Law, we're going to try to turn this around. We may get a few guys like this, but we want them to graduate here. And if they arrive and have kind of been shellacked in a few ways, we want them to graduate and uphold high standards and high ethics, right? So anyway, I saw this. I knew you'd want to see it. It's just too funny. So now, a little more serious. So Lord Acton, the quote, "Absolute power corrupts absolutely." Lord Acton. He's been called the magistrate of history because he spent his entire life looking at civilizations and why they flourished and why they fell. And after he did decades of work, and boy, he was one of the leading thinkers in England in his day, the famous line, absolute power, when it comes to government, absolute power corrupts absolutely. So I know I'm talking about first principles, and all of you know this first slide, I am sure. But our own state constitution says that we should have a frequent recurrence to fundamental principles. So tonight, we're going to go back and have a review of a foundational doctrine known as separation of powers. So, separation of powers in this country has been exercised with a tripartite structure of government, both at the federal level and at the state level. And it's actually amazing how similar the state governments are in alignment in this tripartite structure. We know what? Nebraska has a unicameral legislature. And I spent time in Nebraska when the Chief Justice invited us out, and we met these legislators from the unicameral entity in Nebraska. And they were just like us, except they were pretty much nonpartisan elections. The Republican Party predominated in Nebraska. But it was very interesting that you didn't have bicameralism in the legislative branch in the state of Nebraska. So, what is the major objective of separation of powers? Let's say it together. To preserve liberty. Wait a minute, a few people didn't take part. Let's say it again. The chief goal of separation of powers is to preserve liberty. Yes, so we're here to talk about liberty. Now, some people talk about freedom, the associated concept, also very, very important, right? But if we go back to the time of the founding and historically, typically the term liberty was used because rights were viewed as coming from God. Governments encroached on those rights to the degree necessary to advance the cause of civilization, safety of people living together, etc. So, our own Supreme Court has recognized this principle. Quote, "Our founders believed that separating the legislative, executive, and judicial powers of state government was necessary for the preservation of liberty," a 2016 decision. So what's our historical justification? Is anybody aware of the Federalist Papers? Wow. You know, I've participated in national polls, the methodology, putting them together. And in 2009, I worked with the National Center for State Courts on a poll to ascertain civic awareness among Americans. And what I just saw here is amazing. You're doing well, Brett. You have a highly literate crowd. Did you know that only 1 out of 4 Americans can name the 3 branches of government? 1 out of 4? That's scary. So let's do it together. The 3 branches of government are legislative, executive, and judicial. Now I want to ask you what they do because we might lose a couple, but I'm kidding. Mainly why we would lose a couple is there's been such role confusion in the modern era. So tonight we're here to talk about first principles. So James Madison was involved in the preparation of the Federalist Papers along with Alexander Hamilton, and they were generally drafted to help the new Constitution be ratified in America, the United States Constitution. So Madison said, if men were angels, no government would be necessary. Now, I'll go ahead and tell you that if there is an angel, it's Justice Sam Alito. I've taught law students with him, and you saw it hasn't gotten too far. Don't believe everything you read. I'll leave it there. Okay, so people cannot be trusted with power. Now, I was in government about 30 years, and I will tell you, people cannot always be trusted with power. There's a lot of good people in government. There's others, you wonder why they're there. But you know, I always wonder, why would someone go to 4 years of, remember this, law students, why would somebody go to 4 years of college, 3 years of law school, get licensed, and 2 years later steal $280 from a widow, and get caught and lose their law license? I mean, it's like, wait a minute, I can save you some money. Don't go to college. Don't spend the money on that. Opportunity cost of 4 years, all the money. 3 years of law school. It's very hard to steal $280 and lose your law license. So anyway, for those that want to do that, I wonder why they go in government, and I wonder why they go in the practice of law. They could have saved a lot of time and money, right? So anyway, this principle goes back a long way, because we know that people can be, I'm a little more optimistic than Ben was. He says they are selfish. I'm going to say they can be selfish, passionate, full of whims, caprices, and prejudices. Enough on that. Okay, so Greco-Roman history. If we look at the great civilizations that we've seen on the earth, Aristotle identified 3 elements of governance. The deliberative, making the rules of society, the magisterial, an executive carrying out functions for society, and the judicial. He didn't advocate for strict separation, but the ideal was born so that others could try to build on that over time. So the Romans, who borrowed a lot of their culture and principles of government from the Greeks, the Romans had several noted philosophers who contributed to the doctrine. Polybius noted that the Roman Constitution had 3 elements, and Cicero, I'm a big fan of Cicero because he was for good government. I'm always for those who stand up for good government. So Cicero, his time was toward the end of the Republic itself. And he really said there's really no form of government that doesn't have 3 elements, whether we recognize it or not. And unless an equal balance, notice that concept of equal branches coming in several thousand years ago, the government cannot be whole and entire. And so Cicero made great contributions to modern notions of good government. Well, the Old Testament. Surprise, surprise. The book of Deuteronomy, which, if you're familiar with the Bible, you know it's toward the beginning. If you're not familiar with it, it's toward the beginning. Deuteronomy chapters 16 to 18 set out some of these same principles. I can't speak for God, but apparently he initially wanted just judges, priests, and prophets, but the people clamored for a king. So we saw that 4th element inserted. Enlightenment thinkers, which we know, I know this crowd knows well, probably the most direct influence on the founders and how they structured our government as represented in the United States Constitution. So John Locke, has anybody heard of John Locke? Oh, I love this audience. John Locke argued for a division of government into distinct branches. Notice it says to safeguard liberty, prevent abuse of power. Boy, we need another John Locke today, don't we? He's specifically advocating separating the legislative and executive functions. He saw great problems with those 2 powers being commingled. And his work was improved by Montesquieu. Montesquieu articulated really a more systematic approach, directly relevant to what the founders did in the tripartite structure. So, legislative, executive, and judiciary. One of his main contributions is raising the specter of really the horrible things that can happen if you had a great commingling of these separate powers. There can be no liberty, according to Montesquieu, where the legislative and executive powers are united in the same person or small group of individuals. Well, our founding era, The framers of our Constitution, especially Madison, one of the authors of the Federalist Papers, were heavily influenced by Montesquieu and designed a government based on separation of powers in the first 3 articles of the United States Constitution. Now we're going to go for the gold star. Article 1 of the United States Constitution. What is it about? This is for the gold star. Who? Right here? Yeah, it's legislative. Good. Somebody got it. You get the gold star. All right. What's Article 2 about? Okay, good. You guys, beyond belief how well you're doing. You didn't even know it was going to be participatory, did you? Okay, so what's Article 3? Yes, okay. Even if you didn't get the other 2, you had a pretty good shot on that one, didn't you? Process of elimination. I hear you back there. Okay, so this is for the double gold star. Now we're going to go to the state constitution of the state that you're at least, you may not be a resident of North Carolina, but you're here right now. You want to come to the club, so you're at least passing through. Okay, so Article 1 of the state constitution. What is it about?
Declaration of Rights.
Wow. The double gold star. What is your name?
Nathan Wilson.
Nathan gets the double gold star. And you know why? Because it's different from the U.S. Constitution. Now, I'll give you a hint. Once we get by that discrepancy, it gets easier. So I know you know I know you know everything about this Constitution. I'm your LinkedIn connection. I watched you in action in Marble. So we have a great man among us. Really an extraordinary appellate lawyer. So I'm going to let you get a little more credit. What's Article 2 about?
Legislative.
Right. Now, you getting the drift here? I wonder what Article 3 of the state constitution's about.
Exactly.
There we go. My employee did well. Okay. So, as if there was no suspense remaining, what is Article 4 of the state constitution about?
Judicial.
Wow. You guys all get an A+. All right. So, the framers said we have to do this, or else we will eventually have despotism. We will eventually have tyranny. And what did Ben Franklin say when asked about what they had been working on in Philadelphia, at least what he's reputed to have said? It's a republic if
They can keep
we
it.
can keep it. And Justice Gorsuch is a friend, and so I bought several copies of his book along those lines. And the U.S. Marshal said that he didn't have time to sign anyone's book, but he put a few comments in mine. And I think he really has an excellent treatise on this, because the founders thought, well, in our generation, we can probably do pretty well with this. But then it's going to fall to every succeeding generation to really grasp these principles that preserve liberty and perpetuate them to future generations. So there was also a natural right aspect of this. The founders believed that there was a God, and that he had certain principles that men and women were entitled to, whether a government said they were or not. Now, what's the cruel fact about history? Normally, when these liberties have been possessed, has been an exception. Governments have all too frequently tried to take away rights, and the history of mankind is a fierce battle of individuals and families and communities to preserve these unalienable, also known as inalienable rights. In his farewell address, President George Washington, I know I don't need to tell any of us who he was, lauded the separation of powers and urged the new country to reject consolidation of powers because what? It would create, quote, a real despotism. So, we'll talk about one very old case. So, in that first generation, we had a Chief Justice, John Marshall, made a lot of contributions to the really establishing the credibility of the Supreme Court, which led one of the 3 branches at the federal level. And in 1803, a decision was issued known as Marbury v. Madison. Now, suffice it for our purposes simply to say, this case established the principle of judicial review, so that the actions of the actions of the legislative branch and the executive branch should be evaluated to ensure that they were constitutional within the bounds of the Constitution. Innocent enough, we know we can fast forward to the present era and talk about, are the judges also imposing separation of powers principles on themselves? And I won't make any comments about that because I'm sure everybody already has their own opinions on that. So we fast forward to 1952. Harry Truman is president. The nation is again at war, the Korean War. The American public was very tired of war. We had just fought World War II. I was born in the 1800s, so I remember saying this. And the public's really tired of war. And, but we have this little persnickety problem called the Korean War, and a lot of Americans lost their lives in that war. It's one of the early ones that in many respects was viewed as a police action rather than an actual war. But in any event, for our purposes, Truman was very concerned to make sure that the troops on the ground had the supplies they needed. There were a lot of Chinese troops that were eventually thrown into the battle, and Truman wanted his troops to have proper tanks and equipment. He seizes the steel mills. Sounds innocent enough, time of emergency. But the principle of separation of powers was still so steeply ingrained in our national governance structure that the Supreme Court said, no, your seizure of the steel mills is unconstitutional. The various justices had various rationales for the opinion, but for our purposes, it's an illustration of a limitation upon executive power. Now, let's go back. You know, hey, I'm a law professor, so this is more like a class tonight, right? So what we realize is that by articulating a standard for seizure of the steel mills, which is typically a legislative determination, and then carrying out that edict, which is an executive branch function, Truman had commingled two branches. And those justices said, nope, you can't do that. And so it's pretty amazing. Oral arguments were held within, you'll appreciate this, Nathan, oral arguments were held within 3 weeks of the challenge by the steel companies at the Supreme Court of the United States, 3 weeks after the complaint was filed. And the justices set aside 5 hours for oral argument, and the opinion was issued 10 days later. Pretty impressive. We aren't able to do quite that good anymore. I remember when I was Chief Justice, we had a few opinions that needed to get out quickly, and that meant 3 months. So, all right, INSV Chata, and the reason I have this in here is it's an example of a limitation on the legislative branch here at the federal level of Congress. And the idea of a legislative veto is a good one. We were already starting to see U.S. presidents that were making assertions of power that seemed to flow far beyond the inherent authority of the United States president, because in fact, Article 2 has very few express powers for the president. So in the 20th century, the whole ballgame was about, well, what's the degree and breadth of inherent authority of the president? So Congress said, you know, how do we put a cap on this? Oh, we know. If one chamber of Congress, we know there's a House and the Senate, if one chamber of Congress disapproves of executive action, it can't proceed. It's invalidated. But yet the Supreme Court said, legislative branch, that goes beyond your role. And you too are limited, because you are now commingling, and I'm giving this at a high thematic level, you're now commingling legislative and executive authority. So, you may love the administrative state, you may hate the administrative state. My point tonight is not to be normative, but descriptive about where we stand. So often deemed the fourth branch of government, the administrative state includes myriad alphabet organizations. I don't need to tell you about this at the federal level. Now it's really interesting, the founders thought that the greatest threat would be from Congress itself. That has not turned out to be the case. But instead, we now have this phalanx of administrative agencies which obviously do legitimate things for the people of America. But we also see an interesting phenomenon that the founders didn't quite know would take place. And that is that a modern agency can wield legislative authority, executive authority, and judicial authority. The very definition of potential tyranny. The very set of circumstances that the founders said could create despotism. So, hold on to your hat. We're going to talk about that a little bit. Let's go on just to move forward. I'm under strict orders to finish on time. And gosh darn, we're going to do it, Brad. So, birth of the administrative state. So progressives in the late 19th and 20th centuries, about 100 years or so after the Constitution has been ratified, they're saying, well, look, we've gone through the early cycle. We're a growing nation. Now we need to learn how to administer it. Now, so they thought, let's really look to really, really smart people. And let's bring them to Washington, and they'll be able to take care of us all. And that was the theory. And so we come into the 20th century, and Woodrow Wilson says, the period of constitution making is past. Now we've reached this new territory in which we need new guides, the vast territory of administration. So, what was the fundamental assumption? That good government folks would go into these roles, and we know there's a lot of good government folks. Think about Justice Barringer tonight, an exceptional public servant. I'm no longer a judge, so I can say the truth, and when it's merited like that. So, then came the New Deal. So we had this economic threat. We're coming out of the Roaring 20s, and the federal government expands authority into new areas. Just imagine being alive at that point. You're starting to see governmental assertions of authority that had never happened before. So pretty shocking to many in that generation. But more was to come. Now, there are so many fun parts to this decision. This decision, Justice Gorsuch's mother is the EPA head at this point in time. You just can't make up these facts. And I'll talk about Justice Gorsuch in a minute. But in the case of Chevron versus NRDC 1984 Supreme Court decision, the Supreme Court said, when Congress has passed a statute and you can't tell what they mean from the statute itself. Now, wait a minute. Lawyers in the room. Can you ever tell what a federal statute means by reading it? There are ambiguities leaping from A to Z in that 1,200-page document. And so who is to make sense out of that document? Well, the agency. And that's what's happened. But what's happened? Think about our first principles. And this is the triple gold star, but it's very, very easy. What is the function of the legislative branch?
Make law.
Make laws. So wait a minute. They were supposed to be making these policy decisions. They were supposed to be listening to various constituent groups, having open government hearings and meetings and getting all the viewpoints. And then in the way the founders thought, coming up with some compromise on policy. Well, we know that's not always happening, to put it politely. So in Chevron, the Supreme Court's looking at this reality that so much law is made at the agency level. And they're saying, can courts really micromanage this? So where the text was ambiguous, we're silent. As long as the agency judgment was, lawyers in the room, reasonable, the court would not disrupt that. Now, prior to his elevation to the Supreme Court, 10th Circuit Judge Gorsuch, who lived right outside Denver, Colorado, he said, well, wait a minute. We have corrupted the role that we inherited from Marbury of declaring what the law is to just assessing what's reasonable. So that's not right. And he started in his 10th Circuit days really a new examination of should courts return to the sense of declaring what the law is and not having that degree of deference to agencies. Now, since Chevron, for those few administrative law lawyers in the room, you know how the clarifying doctrine has been over the last 40 years or so. But Chevron requires the court to defer to any reasonable agency interpretation where the statute is ambiguous or silent. Now, in practice, Chevron has created a situation where, often agencies do a very good job. We're not here to make overbroad categorical criticisms, but there have been some occasions, at least, where people have wondered, is that really what Congress had in mind? So, I signed on to an amicus brief at the U.S. Supreme Court a number of months ago because I felt like that we really ought to be re-examining Chevron fundamentally and really making sure that agency creep, agencies were not asserting more authority than Congress had intended, because even though we see the vast reach of modern administrative agencies, who is supposed to be setting policy for the people of America? Congress, the legislative branch. So, you'll love this. So in the Loper case, fishermen challenged a discovered power, previously unknown, in a congressional act to require small fishing vessels to pay for sea monitors. I don't know. I didn't know if I went fishing I had to have a monitor come along. So this is something really unusual, but these people rode along to ensure compliance with regulations. Sounds like a good use of taxpayer money. So anyway, the plaintiffs argue that Chevron allows these agencies to actually usurp the court's power in declaring what the law is and Congress's power to write laws. Notice that theme is flowing from the critique of Judge Gorsuch going back a number of years. So I signed on to this friend of the court brief just to, you kind of put it in the hopper and hope the judges read it to the extent it's helpful to them. And this opinion should be coming out in the next 2 or 3 weeks. So if you hear a case about fishermen and about separation of powers in Chevron, that's the case. Okay, so we've also had what the courts have deemed recent executive overreach at the federal level. I know lawyers in the room are very familiar with the case Biden v. Nebraska. That's the big federal student loan case. So Joe Biden was campaigning for president. He said, if I'm elected, everybody will get $10K federal loan forgiveness. And so, to his credit, he gets elected. There were many that wanted him to go far beyond that, but he gave the $10K forgiveness proposal, and the Supreme Court struck it down. So, for purposes of the night, we'll run through this quickly. It was because, again, at a very global level, a commingling of the legislative power and the executive power. The Biden administration was determining the standards for loan forgiveness. They cited to a few provisions of the HEROES Act, but the reality is that Congress had never intended for the executive branch to forgive $430 billion in outstanding obligations to lenders in that program, and ultimately the guarantor, the taxpayers of America. West Virginia v. EPA, fascinating decision, very lengthy. We'll go with a one-liner. Supreme Court holds that the EPA overstepped its delegated statutory authority under the Clean Power Plan, federal law, to set a carbon dioxide emission cap on all states. Now we have the emergence of what's called the major questions doctrine, where the Supreme Court looks at the situation and says, well, wait a minute, this is really important. Should we require Congress to articulate policy on such a vast and comprehensive issue for the American people? It's a fascinating doctrine. Even if you're not a lawyer, read one of these cases and you'll learn a lot. So the last one, the National Federation of Independent Business versus OSHA. Yes, this is one of the twin decisions that came out during the pandemic. This was not the healthcare one. And this one was struck by the court. The other was upheld for those that worked in healthcare organizations. Biden's OSHA vaccine mandate on private employers, because the states and Congress had the authority to decide how to respond to the COVID-19 pandemic. How you respond is, the fourth gold star, is a what kind of determination? Policy determination. Who should be doing that in a perfect world? The legislative branch. Okay, now we're going to have a little bit of fun, then I'm done. All right, Sackett. Has anybody heard of Sackett? Wow.
I work with Pacific Legal Foundation.
Oh, well, you guys brought the case. Did you know that? Your organization brought the case? Okay, so this is great. The Sacketts worked their whole lives to retire at this beautiful lake in the state of Idaho. They buy a lot for $23,000. Sound like wealthy folks to you? They worked all their lives to raise that money. Their home was just going to be on a row of houses with other houses, with homes already in place. You would say, well, that's just a neighborhood. Well, the EPA had another take. The EPA said, you're building that home on wetlands. So they buy the land in 04, they start building in 07. Oh no, it gets better. 2007, 3 years later, they start building. Unannounced, the EPA shows up on the work site. If you come out here each day, you come out and do anything on this lot, you'll be fined tens of thousands of dollars. At one time it was $75,000, but then they said, no, we never said that. But it was a lot of twists and turns in litigation. But here's this middle-class family that was going to have to pay tens of thousands in regulatory fines per day if they made the slightest move to build their home. Now, I want you to put yourself in the place of the Sacketts. They had no notice that this might even be an issue. They just bought a lot. This was the culmination of their dreams to retire in a beautiful place in Idaho. But instead, they spend 16 years. The case goes to the Supreme Court of the United States twice. This agency that exercised legislative, executive, and judicial authority did not even give the Sacketts an opportunity to contest any of the claims. Imagine, you're just told that if you come out and try to build on this lot, tens of thousands of dollars in fines per day. Would you be able to afford that? I wouldn't. We're done. You just have this worthless lot. Now, just so we know we learned something tonight, because I know everybody is going to get this right. How is the EPA exercising legislative authority? Anyone? Nathan?
They're going to claim it was delegated.
Right? But what did they have to determine in order to move forward? That there had a framework. Nowhere in the Clean Water Act does it say that you can extend delegation, you can extend authority of what wetlands are to this extent. It was agency delegation. So they're exercising legislative power and making that thematic conclusion that this is forbidden. Executive, well, they show up without any notice, right? They're carrying out the law. They show up and they say, you're done. You do anything else out here, any earth-moving violation, earth-moving activities, whatever, we're going to fine you this amount of money. Well, they also judicial authority, because the Sacketts said we're going to move forward anyway, and the EPA said nope, you can't do it. We adjudicated that you're in violation. So this agency, the very thing the founders wanted against, the commingling, the combination of all government authority. Notice that I bet there's not anybody in this room that agrees with the EPA. Is there anybody that agrees with the EPA on these facts? Okay, so I think we're all in agreement that the very thing the founders warned us about took place in this case. Now what's the good news? The Supreme Court unanimously corrected it. 9-0, which doesn't always happen all the time in this day and time. So, isn't it interesting? They fought for 16 years. But then if you add the period of time they bought the property, that's 19 years, almost 20 years. Well, the Sacketts were not 16. I want you to think about this. We're a country predicated on liberty and freedom. Would you want to buy a plot of property and then have to fight the government for 20 years to enjoy your property that you've worked your entire life to do? Is this right? Is this just? Is this what the founders had in mind? And you know what? It's very unusual for a case like this to get all the way to the Supreme Court of the United States. God bless Pacific Legal Foundation for what they did. Because you know what happens most of the time to millions of other people? They don't even contest it. And these commingling of government authority, where there's oppression in circumstances, many people suffer oppression in this great land. So, in Bastiat, we care a lot about economic liberty. How does separation of powers impact like that? Well, if we don't have separation of powers, what if these Sacketts had been a business? Right? A $23,000 business investment to go into business, try to make a living, and then a 20-year delay. No profit during that 20 years. Does that say what the founders had in mind? I don't think so. So, liberty is a key ingredient to a flourishing market system where business individuals that fuel this great country with just building great revenues for our great universities and just great neighborhoods like McGregor Downs, probably the most prosperous nation that's ever existed in the history of the world, the United States of America, predicated on the concept of economic liberty, associated to the concept of separation of powers that limited governmental authority and prevented oppression. Human dignity. Do you think that the Sacketts felt that they were respected in this process? Do you feel like that human dignity was respected here for this family that just wanted to pursue their dreams? So an attack on liberty cuts to the core of being free individuals with inalienable rights from our Creator. So, at High Point School of Law, we are working to help preserve liberty through supporting separation of powers. So there we go, and I want you guys to see a photo of Kim. You can tell from her the way she's looking. She's thinking, is he really sure what he's getting into? And so I'll tell a funny story on us. I mean, now she really looks like that, doesn't she? She's like, does this guy really know what he's getting into? This is when I took the oath of Chief Justice. So halfway through, I was working 7 days a week, always had a suit on 15 hours a day, and loving every moment of it. But then one night I came home and she said, and by the way, we just celebrated our 30th anniversary, so. But she said, do you still want to be married? You know, it's one of those bad days. I said, honey, you're the most important thing to me in the world. She said, well, that's funny because I never see you. So at that point, the Chief Justice stopped working 7 days a week. We had the commission done, Nathan. And then I started working 6 days a week. So God bless Paul Newby because he's now working that 7 days a week. So this has been so much fun. I know we have some Q&A, but thank you so much for giving me a chance to talk to you about a topic that is near and dear to my heart and should be near and dear to the heart of every American. Thank you so much.
Well, you bring back to mind just how important this thing that we take for granted, this doctrine, we kind of throw it around. Maybe people learned about it in 5th grade or something. Separation of powers, you know. President, Congress, and the Supreme Court. There you go. Okay, next topic. You know, no, wait a second. This is being combined in powers that are absolutely and completely violating our rights as citizens that we expect here in the United States. Thank you so much. So, why don't we take some questions? Anybody have any questions?
All right, I'm gonna get you with a hard one, Chief Justice.
My friend from Apex.
That's it, yes, sir. So you know me and you sort of know my background, so this will make some sense. Where do we? Okay, so I think we all understand in this room that the overarching federal government and their bureaucracy are out of line with some of these things we're doing. But where do we draw the line? Is it the municipality's planning official when they impose fines for somebody? Is it the HOA? Is it the police officer that decides, uses their discretion to determine how they enforce the law? Is it the vice principal that determines, well, what do I do in this case? So where is it okay that every decision doesn't have to be adjudicated in a court of law? Where's your line?
Well, it's my hope that we would see less litigation in America and that more things would be resolved between individuals of good faith. Since I left the bench, I became a certified mediator. So I spend a lot of time trying to keep people out of court. But to answer your question, I think each American should know enough about our government, know its basic civics aspects here, where a lot of things can be worked out. Obviously, in a police force, the chief is going to have unlimited authority. But it only extends to the police force, right? The rest of us have liberty to go about our business. And unless we transgress the rules of society, in a mild way, we call that civil liability. If we transgress the community conscience, we violate criminal laws. The problem in the last 40 or 50 years is we've seen everything blur, okay? We should have a zone of liberty where you pretty much know what you can do, what you can't. Does any lawyer in the room feel like they know all the law? I certainly don't, right? So even the lawyers don't know the law. So probably every American is in violation of something. And so we really need a curtailment of a lot of the new rules and look at the old rules and make sure they make sense. And we've seen in recent years a lot of inventive and creative uses of law, but half the time people would not even have notice, fundamentally fair opportunity to know what the rules are. So you raise a great question. Criminal law should not be predicated years after operative events to say, gotcha. At the time you made a decision, there should be an awareness that this might transgress the criminal law. And that's where we've gotten away in this country. You could go out and do something having no idea that you violated the law. And that's a grave problem in the 21st century. And so that's why our diligence has to extend to make sure that we're working together in communities and citizens across the country to understand what the rules of the road are, to hold each of us accountable, but also to hold government accountable. And I say that as someone who spent most of my professional career in government. So it's a great question.
Do you think there's any benefit of busting up the DOJ, the opposites, right? DOJ, EPA, these organizations that have evolved over the years, and just put them out at the state level, and then the states have to vote who is in charge, and there's some sort of accountability, and there's some sort of jurisdiction, or they have some accountability to the three branches in the state.
Well, there are a lot of specific thoughts right now about how to restore the proper balance. I think we're out of balance right now. Does anybody in the room think the government is working functionally in all respects? I mean, we're never going to have perfect government, so it's always going to be this approximation of how government is doing. We, the people, have to keep government accountable, and it's a perennial struggle. And if we don't pass along these important considerations to our posterity, as Ronald Reagan said, we'll go just a couple generations and not even recognize the America we live in.
Yeah, the point I'm making is these people, like, are running the DOJ and the EPA, right? They're unelected. They're unelected people, right? So, who would they accountable to?
Well, I mean, I think your argument has great sympathy among those assembled here tonight. And that's where we have to make sure that there is the requisite political accountability in modern administrative units to some person that the American people, there is accountability back to the people. Now, a political scientist would say the answer to your question is simple. You elect a president, you elect people to Congress, and then in a very much an aggregate way, those entities establish administrative agencies and fill them, at least at the higher levels, policy-making level. We know there's a lot of other people hired, going back to what Woodrow Wilson and others tried to start us down the road of a long time ago. But if you want a specific, fun little presentation to watch about the topic at Hillsdale College, and the speaker was none other than Newt Gingrich, and the topic, you can find it on YouTube, is how to restore DOJ. And it's a short watch. And for those of you that are interested in that specific topic, it's a really good lecture.
Professor?
Thank you, Justice. The original cabinet agencies, if I recall, there were only 4 of them, State, War, Justice, and Treasury.
That's
And there are
correct.
now 60. Would you class it, so these are apart from the 3-letter agencies, as you talked about.
Yeah.
The OSHA is different than the Department of Agriculture. Is it similar in the cabinet agencies that the 14 extra that we've added? Are they also a form of united powers in the sense that the Department of Agriculture also is issuing law, issuing rules and stuff? The Federal Register captures both, all of them together, but is it a similar problem in the executive cabinet agencies, in which case we should target the abolition of some of them?
Well, remember, isn't it interesting? Ronald Reagan ran for president. He said, I'm gonna eliminate the Department of Education.
Yeah.
He didn't succeed. After 4 long years, he had only eliminated one federal function, the Civil Aeronautics Board, that had not done anything meaningful for a long time. So what we're dealing with is inertia here, right? Once things are put into motion, we have people that get their paycheck from that, they support their family. It's very hard once you have this furtive growth. It's very difficult. And I think the only way you can really get some containment and reduction in appropriate areas is through a lot of intentionality, because inertia is not ever going to lead us in that direction. When George H.W. Bush became president, the CFR doubled in 4 years. A Republican nominee that told America, we're going to, carefully watch the federal government, CFR doubled in 4 years. So, that's the natural thing. Now, we can all have different normative assessments of whether that needed to happen, but I think the American people need to have a lot more intentionality of staying in touch with government. Why did Jefferson think the best government was closest to the people? Because it's very hard for us out in the provinces to keep track of what the Department of Labor in Washington is doing on any particular day. So it's a fascinating concept. One thing that we thought about a lot at the Supreme Court is on the federal level, you had these so-called independent agencies, and they weren't really a part of any branch. Now, we haven't had time tonight to get into this, but I dropped a footnote into one of my opinions one time, and I said, well, it's not germane to the case, so we're not going to talk about it, just to let the lawyers know that we weren't trying to say anything about this, because there were those that says, well, at the state level, the same thing. We want the SBI to be kind of independent over by itself. Well, the SBI does a lot of great work. But I mean, at the end of the day, who are they accountable to? Well, the governor. Well, they're not in a separate branch, they're in the executive branch.
Yeah. More questions? Okay, so 7:26, we have time for one more question, I think.
And I'll hang around for anybody that wants
Yeah,
to
hey,
check.
we can,
So-
yeah, definitely. In the back there,
I wanted to ask about the Heritage 2025 project that enables Trump to hit the ground running and
Yeah.
replace thousands of agency heads.
You'd
Are
be
the legal
very proud of what they're
precedents
doing, but go ahead.
to defend that in place, or are the legal precedents, the rulings in place to defend that? Can that approach possibly succeed in your view?
Okay, when I was on the bench, I probably could not have known about this, but Project 2025 is sophisticated, a lot of resources, and they're really doing an excellent job trying to end the event. And Heritage is like Bastiat, they're not a partisan organization. So what they say is, in the event a conservative government is elected that has interest in what we offer, we're going to be here to share. So I'm not going to mischaracterize the Heritage mission. But they're looking at every level of analysis, and I guarantee you that these principles tonight are foremost in mind of what they're trying to achieve. Look, government changes over time. It's either going to get better or it's going to get worse. It's never going to stay the same. It's just like all of us. We grow up and then we start aging. We may not like that, right? I'm glad I'm still 39, but we're going to age. And all organisms, individual, governmental, we all change. It's up to us to make sure government moves in a positive direction. If we don't do it, no one will. Look, we might look at Project 2025 and say, well, I disagree with this one thing over here. Hey, give them the benefit of the doubt. What are they trying to do? They're trying to return accountability to the greatest extent possible by the federal government to the American people.
Wow, that's awesome. In terms of just explaining Project 2025 and also encouraging people to get involved. That's what I really want to do. And thank you so much again.
Oh, you bet.
You see my California roots, so I'm using words like awesome, stuff like that. You'll see a QR code on your table. That's in case you moved to want to contribute to the Bastiat Society. You can just open that little QR code and it'll take you to a donation page. And if you have any trouble with that, I'm sure Michael Farrell would love to help you with that. So anyway, thank you very much. And we will see you in September when we will have our very own Professor Saltzman address the issue of the Biden loan forgiveness. Ooh. And then in October, we will have a Joanne Florino, who's going to be talking on donor intent. And Jenna, you're with James D. Martin Foundation.
Right, so Joanne Florino works as a political ground deal, and she's going to talk about the importance of donor intent, which means when donors give to particular causes, if universities or other entities that they give to actually respect what the donor wants to have done with that money. And so it's a very important topic, especially with our universities. You're not always respecting donor intent these days.
Right, so if you have a lot of money, you give it to the university and they do the exact opposite thing, that's not so great. And then in November, we'll have Mitch Kokai with John Locke give us a legislative wrap-up. And I hope you all have a wonderful summer. Thank you very much.